Item 17 CMP 608 of 2025.
Petitioner absent. Post on 21st August.
Item 18 CMP 1105 of 2025.
Petitioner absent. Okay. बताइए.
Yes, notice to issue CAP matter. As per the office report, copy number 1, 4 to 11, 13 and 14 have been noted. Copy number 2, 3 died. Sufficient and division of the parties loss. I number 6164. For substitution of petitioner number 1, 9, 18, 19, and open number 3 and open number 12.
They have filed counter also to this.
Yes, it's counter.
Counsel for the petitioner is present. Nobody appears on behalf of the respondents. Post on 3rd of, sorry, the 10th of May.
Item 19 CRLP 1198 of 2025.
Yes.
I haven't had an update for the amendment in the prayer. The charge
Prayer?
sheet, before it, the FIR only lost and annexed with the main criminal miscellaneous petition. And now the charge sheet also have been filed.
CRLP is listed before me.
That's signed.
You file this one.
Caution the FIR. Cognizance has also been taken by
So
the
the
judge.
entire tenor of the case would change, isn't it?
Prior to this, the FIR only, we have prayed for the quashing the FIR, and now the IS file, where the cognizance order and the charge sheet. And now I'm praying for the quashing the FIR with the cognizance order and charge sheet also.
ID number
8830.
8830/26. This petition has been filed for petition of prayer in the main petition. The learned counsel says that during the pendency of this case, cognizance has been taken on 17/10/2025 for offence under section 406, 420 and 506 of IPC. The main petition was filed for quashing of the FIR and on account of subsequent development, the order taking cognizance is also under challenge. Any objection? The learned counsel for the state has no objection. Considering the submissions, ID number 8830/26 is allowed. The learned counsel for the petitioner is directed to carry out necessary amendments in the main petition in writing during the course of the day. What is the matter? Yes, what's there on merit?
Basically, the matter was the arising out of the land dispute, which already sale, and the sale deed already we have, and the matter is actually happened in 2023, and the FIR complaint is lodged after the 5 year of that. and the basic allegation is that कि वो जो अमाउंट पे डील हुआ था कि 50 लाख का जमीन दिया गया, 5 लाख से दिया गया है और सेल भी ले लिया गया है, रजिस्ट्री हो चुका है, जो कि फॉल्स है, वो पूरा पे करके दिया है। और ये जो गैपिंग है मैम डॉट से, that is also is questionable, that this is a totally matter of the civil nature and जानबूझ के petitioner को harass करने के लिए criminal matter में इसको लाया।
Issue notice to OP number 2 through the concerned police station. The affidavit regarding
Some name is
it is there. Tanveer Alam. You can take this name. इसका नाम लिख लीजिएगा OP number 2 का. ठीक है. The notice should accompany the main petition as well as the interlocutory application. दोनों फाइल कर देंगे. अलाउ तो हम कर दें आपका आइए, लेकिन रीडिंग्स वगैरह अभी आप करेंगे फिर कैसे होगा. The counsel for the state is directed to seek the instructions and file affidavit of service, affidavit regarding service of notice by 17th of July post on 24th. In supplementary process.
Item 20 CMP 307 of 2026.
This petition.
What's the time for respondent one?
Where is the petitioner? Petitioner absent. Post on. Okay, then. What is it?
Restoration.
Restoration. Earlier also it was restored.
Yes.
अब वो कितना पैसा ऐसा जमा करना है?
पैसा जमा कर दिया और इसमें 10,000 एक्स्ट्रा जमा हो गया।
सारा रिसीट जमा कर दिया?
जी सब रिसीट जमा कर दिया।
Any objection to restoration?
No.
For the learned counsel appearing on behalf of the parties, this petition has been filed for restoration of SC number. ये प्राइवेट पार्टी को नोटिस हुआ है? You have for the private party.
But
1 and 2.
1 and 2, but we have not received the original say.
You will get it. All the learned counsels appearing on behalf of the parties, this petition has been filed for restoration of SA number 349 of 2018, which has been dismissed on 16 to 2026 due to non-removal of defects.
जी
Due to non-removal of defects. Due to non-compliance of order dated.
20,000 rupees cost जमा करना।
Due to non-compliance of order dated 9/12/2025. Inasmuch as the cost was not deposited, the learned counsel submits that the cost has already been deposited.
नो सबमिशन। इन्होंने लास्ट डेट में कहा था कि 10,000 रुपए कॉस्ट हमने नहीं पे किया है, वो ऑलरेडी पे किया हुआ था। इनका 5,000 कॉस्ट एक बार हुआ था, वो ऑलरेडी पेड था, तो 10,000 रुपीज इन पार्टी को एक्स्ट्रा हमने दे दिया।
तो हम ये आप लोग को क्या कहना है?
ये लड़की पिछली बार का ऑर्डर है।
I just do not इस तरह को oral submission से कैसे ही हो?
हाँ लेकिन ऑन रिकॉर्ड
On record, what is there?
they will not controvert it perhaps.
Lordship, 2 times earlier the CMP has been dismissed for default.
Yes.
It is in this particular 3G.
Hmm.
And last order you say the order of Honorable High Court, they didn't comply to deposit 20,000.
Yes.
So I just bring this matter to Honorable.
The 20,000 they have deposited.
This time deposit, earlier 5,000 and 5,000, 2,000.
But
Coordinate bench has decided to give
give it to the litigant.
litigant.
Yes.
Once they had paid, but they didn't object that time. It was not known to them.
Yes, sir.
So
in that order 2 times 5,000 has been given by the concerned coordinator. So this I just bring to honorable.
That amount has been paid or not paid to you?
Last time they paid.
No, it was paid at that time.
We do not know. आप लोग का ये कहानी 5,000 रुपए के लिए कोई ऐसा कोई पिटिशन भी नहीं है and receipt भी नहीं है. Receipt is not there. Where is the receipt?
Restoration के लिए था, तो CMP था, it was paid. Case was
And
restored.
Lordship, last time they submit that we are ready to comply all order because this is third consecutive time this CMP has been filed for
Yes,
restoration.
this is what you agreed to pay.
इन्होंने कहा कि नहीं पे किया, हमने लोग अगर ये कह रहे हैं तो
They didn't object. They didn't object.
That has been paid.
that was paid earlier also, second time also we have paid that, and money has extra paid twice. That is also.
So there is an order that you had undertaken to pay. Then you file a modification. आपके ऐसे कुछ भी नहीं मालूम होता तो आप बोलते हैं क्या? How is it possible? अभी आपका second appeal restoration का मुहूर्त नहीं आया. Because CMP number 3.
You already should have passed any order.
Why should I pass any order? Any order किसको बोलते हैं? I can dismiss any order. You are disputing. You are saying that it has been wrongly said that it has not been paid, and you have wrongly undertaken to pay it again. And if you want a modification of that, I will adjourn it because you have to file a interlocutory application seeking a
It may be
modification.
restored, we are not claiming anymore.
CMP number 307 of 2026. The learned counsel for the parties are present. This petition has been filed for restoration of essay number 349 of 2018, which stood dismissed for non-compliance of order dated 9/12/2025 passed in the second appeal. The learned counsel submits that the last order passed by this court has been complied. With regard to deposit of money and payment of cost. The learned counsel for the respondents have no objection so far as prayer for restoration is concerned. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, the second appeal number 349 of 2018 is restored to its original file. The office is required to raise a second appeal before appropriate establishment.
Appearance is item 21.
Opposite party 2 is also appearing. Wakalat now filed on behalf of the opposite party while in the jail sales.
In which case?
Before it serial number 19.
Serial number 19. This is just fine.
अभी आपने FIR वाला
Yes, boss.
इसको चेंज कर दिया. तो वो नहीं क्या करें? Post this case under appropriate heading. आइए तो allow कर दिए, ठीक है? Post this case under appropriate heading on 31st of July. In the meantime, it will be open to the opposite, to the state, to the opposite parties to file a contract. कहाँ है? They are not there. आइए allow करके ना simplicity return कर दीजिए 31st.
Item 21, CMP 624 of 2026.
It's your case.
CMP 331.
Your Honor, sir. आप ही का नाम बोलो.
I'm so sorry, I did not write. This is for restoration of first appeal. There's a delay of 59 days in delivering this. There's a delay of 59 days in filing the CMP. The petitioner here is a senior citizen, Your Worship, and the matter relates to a matrimonial guardianship, where the son of the petitioner have died and they are only survived by their parents. So, in the course, there was the first appeal was listed along with a batch of cases where a covered order was passed for removing defects. Defects were not removed, and therefore the CMP was to dismiss for default.
Counsel for the petitioner is present. If you notice to the sole respondent. in the CNP as well as in the HBPP application in line number 5270/26 seeking confirmation of delay of 59 days in filing the CNP. Through speed post, for which requisites we filed by Wednesday. Office to tax speed post immediately post this case on 24th of July. 21st July, 24th July. So the matter relates to guardianship.
So the son of the petitioner has died, and thereafter entire guardianship has been given to the wife. But the grandparents have some reasons to oppose that guardianship. They have absolutely been denied all the rights of
You are
the
representing the grandparents. Yes.
And rating for fresh filing item 22 WPC 4089 of 2026.
वो हमारे पार्किंग को इन्होंने कमर्शियल स्पेस में रिलायंस ट्रेड कंप्लेंट की 16/2025 से मिलेगा 24/4/2025 उन्होंने पार्किंग स्पेस दिया था इन्होंने पूरा पार्किंग
Why is it listed for orders?
Fresh filing.
Fresh.
पेज नंबर इन पिटीशन पेज नंबर 65
What is the relief? To dispose of the complaint.
यस
Why they are not taking up the complaint?
did not appear वो सिर्फ डाले जा रहे हैं साल भर से कोई appear नहीं हो रहा है
कौन नहीं आते?
अपोजिट रिस्पोंडेंट नंबर 3
तो अगर वो लोग नहीं अपियर हो रहे हैं तो वहाँ आप करिए, आपको जो यू प्रोसीड एक्स पार्टी
एक पार्टी भी नहीं कर रहा है और पूरा पार्किंग को जो रेजिडेंशियल घर था उसको नीचे पेज नंबर 65 पिटीशन पेज नंबर 65 मैंने फोटोग्राफ्स लगाए उसमें पूरा रिलायंस पूरे मेरे पार्किंग को इन्होंने वो करके कर दिया और वो है नहीं
ये कोई रिपिटिशन है, क्या कर रहे हैं आप? When did you file it?
इन 24/4/2025
यहाँ पे रिपिटिशन का फाइल किया 8/1/26 आपके केस में नोटिस कब हुआ था? पहला दिन, फर्स्ट डे?
रीड पिटीशन
नहीं, केस में कंप्लेंट केस में
कंप्लेंट चौबीस 4/25
सर कर नोटिस
नोटिस सर मैंने ट्रैकिंग इनको सबमिट किया
ऑर्डर शीट बता रहा है you were not complying with the order of issuance of notice. First day नहीं, बाद में भी 2-3 days like that हुई. गत आदेश का पालन करें.
मैंने 18/11/25 उसके बाद का ट्रैकिंग मैंने पोस्टल और रिसीव्ड ट्रैकिंग रिपोर्ट दाखिल 18/11/25
Yes, you were sleeping over the matter. 18/11 को आपने दाखिल किया और यहाँ पे 8/1/26 को रिपिटिशन फाइल कर दी. What is this?
कंटिन्यूअस वो कोई आ नहीं रहे उधर से
कब से नहीं आ रहे हैं भाई? You did not comply with the orders of
लास्ट
the
4
court.
डेट्स
WPC number 4089 of 2026. Heard the learned counsel appearing on behalf of the petitioner. This petition has been filed for the following relief. The learned counsel for the petition has submitted that the petition has been filed in view of the fact that the respondent number the Respondent Real Estate Regulation and Development Act, Real Estate Regulation and Development, JRA, is not taking any steps for disposal of the complaint case number 16 of 2025. During the course of hearing, the entire order sheet annexed to the petition has been placed, which reveals that the case was first taken up on 19/6/25 and notice was issued, and for subsequent dates, that is on 15/7/25, 12/8/25, 9/9/25, 16/10/25, 18/11/25, the petitioner did not file the postal receipt along with the tracking report. It appears that it was the petitioner who was not taking appropriate steps before the court. Tracking report file कर दिए? कहाँ लिखी?
इसमें फाइल नहीं की, वहाँ पे फाइल कर दी, उसके बाद
The learned counsel for the petitioner upon a query of this court has submitted that he has filed a tracking report before the authority, but the same has not been filed of the speakers before the authority, but the same has not been filed before this court, nor any such statement has been made by the petitioner in the writ petition. This court is of the considered view that there is that the records reveal that there was lapses on the part of the petitioner, and the petitioner is seeking a mandamus directing the concerned respondent to dispose of the complaint case. This court finds no merit in this petition, which is hereby dismissed. However, dismissal of the petition will not be a way of the concerned authority to decide the complaint as per.
Appearance of bill. Item 23 DA.05.67 of 2026.
Mayor, this is the second journey of the petitioner, but earlier it was withdrawn. Annexure 1 at page number 11 is the order. Therefore, grant reasonable bail.
What is the fresh ground?
Yes, Lord. Fresh ground.
It was withdrawn, right?
It was withdrawn. Yes, it was withdrawn. Lord, 103 matter relates to 103. Lord, thereafter charges have been framed, and out of 7 charge-sheeted witnesses, 2 have been examined, and both of them have been declared hostile. Lord, during course of investigation, their statements were recorded, and Lord, they had stated that they had seen the petitioner running away from the place of occurrence, and only due to that, Lord, suspicion was raised, and the FIR was lodged against him, which is apparent from the first information report. Now, during course of trial, they have been examined, and Lord, they have stated that, if your lordships may kindly see annexure 3, page number 21 onwards, they have specifically stated घटना के बारे में मुझे कोई जानकारी नहीं है, पुलिस में मेरा कोई
Mr. Having fact given including this case, I similar nature my lord.
You can expedite your trial.
Lord, 5 witnesses are yet to be examined.
We will examine you. You just be ready for the trial.
I am ready, Lord, because since 2024 I am in custody.
They will produce the cases. Very, very serious. बहुत गंदा है. and similar nature का 5.
नहीं सिमिलर नहीं सिमिलर नहीं
मैंने कि इस पांच including this FIR में
सिमिलर नहीं and all those cases I am known
आर्म्स एक्ट का जो देखा जाए बोले
आर्म्स एक्ट का है 17 CLA है सब का है.
सब है
Yes.
देखा जाएगा 5 4 देखा जाएगा
Yes.
पारा 6 देखो
Or the learned counsel is appearing on behalf of the parties. The learned counsel for the petition submits that the petitioner is in custody since 18/10/2024. And earlier the bail application of the petitioner was withdrawn in BA on 19/26 in BA number 8804 of 2025, and it was again filed on 8/5/2026. The learned counsel submits that out of 5 witnesses, only 2 have, out of 7 witnesses, only 2 have been examined, as is apparent from the entry order dated 23/4/2026. He has also submitted that though the petitioner has a number of criminal antecedents, but he is on bail in rest of in all the cases. He has also submitted that the petitioner has been made an accused only on account of suspicion, when it is alleged in the, as it is alleged in the FIR, that the informant saw his the neck of his sons slaughtered, and he saw the petitioner running away from
one Mantosh Tana Bhagat he saw the petitioner running away from the place
and one Mantosh Tanavagar saw the petitioner from running away from the place of offence. The learned counsel for the state has opposed the prayer for bail and has submitted that there are numerous, there are altogether
4 होगा मेरा तो एक
5 criminal cases, including the present one, against the petitioner, and most of them are recorded under the provisions of Arms Act and 17 CLA Act. After hearing the learned counsel for the parties and considering the criminal antecedent of the petitioner, and also that the petitioner is a named accused in the FIR.
Para 3 of my evidence, my lord, the arms used in the crime, my lord, also recover, my lord. The
learned counsel for the state has also submitted that the arms used for the commission of offence has also been recovered from the possession of the petitioner.
no that is
para 3 para
On the basis of confession statement of the petitioner. However, there can be no reason for non-production of witnesses. The learned counsel, the state is directed to ensure that the remaining witnesses are promptly produced before the court. For forensic test,
for Milord, for recovery of the weapon, separate case has been instituted.
Separate case.
हाँ क्योंकि FSL के अगर होगा तो
उसमें अलग से जाएगा ऐसे अलग से यहाँ से
इसके साथ ये टैग नहीं होगा।
वो अलग चाहिए
इसमें FSL आएगा।
Exactly that cannot be my argument at this stage, Lord. But उसमें होता ये कि इसमें evidence करके और भेजते फिर FSL के लिए, because that is a separate case altogether. During course of investigation of this case, and not one arms was recovered. For that, Lord, in this case only that would have been exhibited and thereafter sent for FSL. Separate case was not needed to be, because उसमें जाएगा अगर FSL के लिए तो फिर
the state is directed to ensure that the remaining witnesses / materials collected during investigation be produced before the court. The counsel for the state is directed to communicate this order to the SPO of the concerned district and directly proceed. इसको लगा दीजिए.
Okay.
Item 24, BA 5637 of 2026.
Arms Act का case. Charge sheet has been submitted on lawsuit 8/9/2025.
स्टडी एक साल लगभग हो गया one criminal incident अभी recently तो reject हुआ है क्या stage है this? Yes. What is the stage of the case? Once the case is rejected, you just see it has been recently rejected. कोई बहुत ज़्यादा time नहीं है. It has been rejected on which date? 18/2/26 and 3/6 you file it again. आपको लगता है कि झारखंड में इतना तेजी से ट्रायल होता है? एक साल का सजा हो चुका है, 2 साल. आपको कितने साल का सजा हो? कन्विक्शन हो जाएगा तो कितने साल का सजा होगा? What is the section?
Arms Act 5(1)(b) 1 26 135 Arms Act
352, 351, 61, 2, PNS 25, 1B, 26 and 35 also. स्टेज में नहीं बता रहे.
स्टेट में एविडेंस मैनेज
कितना विटनेस हो गया?
एक भी विटनेस एग्जाम नहीं हुआ.
From where do you say this?
892
You have 2025 का ये rejection order है.
Yes.
You have not even mentioned anything about the witnesses being examined. कुछ नहीं लिखे.
No any witness examination.
चार्ज का फ्रेम
चार्ज टाइम हुआ है योर लॉर्डशिप 8/9/2025. चार्जशीट सबमिट हुआ है. चार्ज फ्रेम 14/11/2025.
14/11/25. The impugn order in this case has been passed on 7/10/2025. Office is directed to call for a report from the concerned court regarding the present status of the case. Post on 30.
Item 25 BA 5667 of 2026.
Earlier withdrawn, is it page number 18, section 2?
Page number
18. 1 minute.
NDPS.
Yes. Commercial quantity is there, lordship. It has been alleged by the police
FSL.
that
FSL.
So the report note, which
Where is that?
No, it has not been received.
From where do you say this?
I got a report note to date, sir.
FSL report has not come.
We are
Come here.
making a template. It has been sent on 26/11/2025. I got the report, that report which has been sent to the.
my humble submission, lordship, is only limited to that. This
Commercial
petitioner,
quantity में कैसे?
जो ये और इनकी वाइफ दोनों साथ में पकड़ा है, पुलिस ने FIR में ये बोला कि दोनों पति पत्नी मिल करके ये सब व्यापार करते हैं. पत्नी को जो बेल हुआ,
पत्नी को तो लेडी ऐसे हो गए. वो देख लिए हैं.
जी,
उनके बच्चे हैं.
जी.
सब क्या?
that is there.
ये number 5667 of 2026. The learned counsel for the petitioner has submitted that the bail application of the petitioner was earlier withdrawn in BA number 9676 of 2025 by order dated 16/2/2026. The co-accused has been enlarged on bail. Co-accused, his wife,
Yes.
has been enlarged on bail in BA number 473537 of 2025 by order dated 5/6/2025. However, during the course of hearing, it is not in dispute that that as per the allegation, commercial quantity of
Just a minute.
of
So I know the report which has been, I did not some next case. So
commercial quantity of
on the next
Lordship.
of syrup.
210 bottles of Honorex cup syrup,
210 bottles of Honorex cough syrup
900 pieces of nitrosan 10 tablets and
Commercial
11
quantity of narcotic substance has been
Yes,
recovered
yes.
from the possession of the petitioner. The counsel for the state has opposed the prayer for bail and has submitted that the co-accused, being a lady and having minor children, was granted bail. The case of the petitioner cannot be seen in the same footing. The perusal of the bail petition itself reveals that the petitioner has 3 criminal antecedents.
yes,
After hearing the learned counsel for the parties and considering the allegation that commercial quantity of narcotic substance has been recovered from the possession, is alleged to have been recovered from the possession of the petitioner. This court is not inclined to enlarge the petitioner on bail. So far as the bail to his wife is concerned, her case certainly stands on different footing, as it was submitted that she is a wife having 2 minor children, a 6-year-old girl and 1.5-year-olds.
one more submission.
Okay.
In this case, 7 charge sheeted witnesses are there. Out of 7, 1 has been examined. So state में
Charge करते हैं.
चार्ज जो होते हैं इसमें चार्ज जो है जो इसमें 15/1/2026 15/1/2026 7 तो गवाह है, 7 में से 1 हो गया.
At this, the learned counsel for the petition has submitted that the charge has been framed on 15/1/2026,
15
and out of 7 charge sheeted witnesses, only 1 witness has been examined. There can be no excuse on the part of the state not to produce the witnesses promptly for the court. The state is directed to produce the remaining witnesses. Promptly before the court. The counsel for the state is directed to communicate this order to the director of institution and to SP of the concerned district.
Item 26, BA 5673 of 2026.
Yes, stage can.
After and 7 other 80% are
After the CBI मिला था तब
सीनियर मिलर तो सीए कैमरा ने कोई हमारे बयान में नाम नहीं है टीआईपी
मेरिट पे रिजेक्टेड है ना
कि
अब आपके पास खाली स्टेज कर
हमारे पास है नहीं वहां
मेरिट पे रिजेक्टेड है हम उसका अपील नहीं सुन रहे करेक्ट if an order is passed on merits I am not the appellate authority I can only see the stage of the case now
मेरे लेकिन जो मिडिल और आके जो मैं ग्रांट किया है उसका भी रिजेक्ट हुआ जो विड्रॉ हुआ था उसका और प्रभात का भी हुआ था जिसका ग्रांट
कहाँ है
लगा है उनका भी रिजेक्ट हुआ था पेज नंबर एनएसए 2 सीरीज में लो
I just want to know from you when the bail application of these petitioners was granted by coordinate court.
No, ये प्रोसेस ग्रांटेड मिल रहा है मिथुन लोरा
नहीं एक तो ये है राकेश कुमार
राकेश ने मिला मिथुन लोरा फर्स्ट पे लगा है मिलो पेज नंबर मिलो 25 मिलो पेज नंबर 25 रन पेज मिलो इनका भी रिजेक्ट
आपका तो सीरिया है
सीरिया मिलो बट नॉट टोटल टीआईपी मिला हमारा टीआईपी जो है
जरूरत नहीं है ना फोन लेके वहाँ पे घूम रहे हैं
नहीं वहाँ पर मिलो तो लोकेलिटी है स्टेशन है
स्टेज पे चार्ज कितने हुए
और
When was the charge framed?
चार्ज फ्रेम में एक भी विटनेस नहीं हुआ.
Charge, when was it framed?
अट्ठाईस एक 2026 में.
FIR पढ़िए तुमने? गाड़ी वाली जला दी है वही है ना?
हाँ वही लेकिन हम हमारा नाम नहीं है. पेज नंबर 79 में मैं
Extortion.
एक्सटॉर्शन डिमांड किया गया है. फुलफिल नहीं हुआ. और हमारे तरफ से राहुल का और ये
राहुल गैंग को
प्रदीप
राहुल गैंग एंड प्रदीप को
उनका पर्चा हमारा इसमें नहीं है.
कितना एंटीसीडेंट?
ठीक है हमारा और बाकी लोगों का सब साथ में. ठीक है वेट करो. पेज नंबर 70 मैं जितेंद्र कुमार 1947 पर इधर रामस्वरूप प्रसाद ऐसा चलवा क्लियर नहीं और क्लियर चलवा.
Third the learned council. Just take what you have to say. You are for the informant. What do you have to say? What do you have to say? He's making a prayer for me. They should be granted. I will record that only, whatever you say. Rejected. आप यहाँ पे मतलब क्या तमाशा चल रहा है? So you are ornamental over here. You can't even read the brief. What is this? Page number 5673 of 2026. For the learned council secretary on behalf of the parties. The learned council for the petitioner submits that the bail application of the petitioner was rejected earlier by BA number 1851 of 2026 by the order dated 16/3/2026, and he has renewed his bail application by filing the same on 8/6/2026. He has submitted that several co-accused persons have been enlarged on bail by coordinate benches and also by this court. He has in particular referred to the bail order granted to one Mithun Lora in BA number 3562 of 2026 by the order dated 15/5/2026. He further submits that neither there is any recovery from the possession of the petitioner and no TIP was conducted. And this aspect of the matter was taken into consideration while granting bail to Mithun Lora, and the case of the petitioner is on similar footing. The learned counsel for the state is present. After going through the FIR has also been placed, and as per the FIR, the petitioner belongs to Rahul gang. And which gang? And Pradeep and the gang of Pradeep Ganju, and is involved in extortion and burning of certain vehicles. After hearing the learned counsel for the state is also present. After hearing the learned counsel for the petitioner and going through the order dated 16/3/2026, rejecting the bail application of the petitioner, this court finds that while considering the bail application, this court has also considered that during investigation through CDR, the mobile number of the petitioner was seen to be found at the place of occurrence. In this view of the matter, the case of the petitioner stands on different footing as that of the others who have been enlarged on bail. This court is not inclined to enlarge the petition on bail.
Item 27, BA 5708 of 2026.
Yes, petition.
Earlier, this case was rejected on.
Where is the FSL report?
That for that, sorry,
What happened?
the FSL is awaiting the
NDPS, commercial quantity 120.
on that absolutely.
20 bottles on from two accused persons, Your Worship, 20 bottles of.
ऐसा part नहीं हो जाता 10 इसका और 10 इसका ऐसा नहीं होता
Yes, Your Worship.
20 is recovered, it will go 20 will go to each one of them. It's what is the commercial quantity?
1 kg.
I do not know 20 bottles will
Well,
constitute-
20
1000 ml हो जाएगा Your Worship.
11 bottles come to our commercial.
commercial हो गया ना?
So ingredients में components में तो कम है Your Worship, जो quantity है उसका, लेकिन Your Worship पूरे ही कप सिरप को ही count किया जाता है.
Count किया ही
Yes, Your Worship. But मेरा reject हुआ था Your Worship, साथ में कोई accused थे जिनका Your Worship antecedent था, petition number 1 थे उसमें वो, और हम petition number 2 थे उसमें, annexure 1 देख रहे थे Your Worship, page number 8. उसमें last में consider भी किया गया कि petition number 2 का antecedent है और मेरा नहीं है Your Worship, और without FSL Your Worship charge sheet has been submitted. ये Your Worship ये break करें उसमें और the stage of trial
Charge कब जमा होगा?
charge
You
sheet
see, you have not said that how much time the FSL will take to give the report.
Lord,
How much time will they take? What series?
Yeah, you have made a representation. Again, we made a representation. First, it was said on 26/11/2025. Again, the reminder has been sent.
17th May को Your Worship charge sheet submit हुई.
Learned counsel for the state is directed to seek instructions from FSL ranking, SMSL ranking, as to how much time it will take to submit the FSL report in connection with the seized material. It has been submitted that कब भेजा है?
26/11/2025.
The material was sent for examination as that as on 26/11/2020. Post on next page.
Item 28, BA 5732 of 2026.
This is the second bail matter. The earlier was dismissed as not pressed. And the allegation against the petitioner is that the husband, who is the petitioner, and the co-wife made obscene video while the victim was taking bath and circulated. Kindly see the impugn order, the earlier order rejecting.
I have not rejected it. It was simply spread.
Withdrawn. Earlier, the order impugned before the trial court. What is the observation of the trial court?
So why do
Because that goes in my favor, my lords. Therefore, I am saying.
so no case made up against it.
My lords, it simply says, however, on the perusal of the screenshot of the alleged obscene video, it is evident that the victim is wearing headphone in her neck. It is common prudence that no one wears headphone while taking bath. Thus, it appears that she herself recorded her video, and the allegation that the petitioner MD Akhtar Hussain and Akhtar Hussain was recording video palpably appears to be false. However, the petitioner husband though did not appear to have recorded the video, but he has been actively involved in circulating the video of the victim with the intention to humiliate her by sending the same to her brother. It was sent, my lord, from my mobile, it is an admitted fact. But it was sent because it was sent, the allegation which the petitioner is alleging against her wife also, that she used to talk with other boys also. And she was making certain videos and he is circulating.
Since when are you in custody?
I am in custody since 2026. And the charge has also been framed on 8/6/2026.
There is an allegation that you sent it to your brother.
Yes, only.
And several other persons that it come in the impugn order specifically of him. The author said his mobile has been seized from his possession, which reveals that from the mobile number, the obscene video has been sent to Nabijan Ansari, Samsar Ansari, Sajjad Ansari, Riyad Ansari, Azad Ansari, and several others in the WhatsApp.
However, the petitioner husband has been actively involved in circulating the video of the victim with the intention to humiliate her by sending the same to her brothers.
भाई लोग चला
brother
गया,
को भी भेज दिया।
भाई लोग को भेज दिया,
हाँ।
उसके बाद भाई लोग अपने भाई लोग को भेज दिए।
इनके अपने भाई को नहीं भेजे, उनके भाई को भेजे। और मतलब इसमें कॉग्निजेंस जो हुआ है, the maximum sentence is of 5 years.
Is that so? Maximum sentence is for
5
5 years. Is that so that the maximum sentence is for 5 years?
Is 67A, 5 years is for the first conviction. Otherwise, the cognizance has been taken under 126(2), that is for 1 month, my lords. 151 and 15(2), 1 year, my lords, maximum.
For the learned counsels appearing on behalf of the parties, the learned counsel for the petitioner submits that he is in custody since 14 to 26. The charge sheet has been submitted. The petitioner happens to be the husband of the victim, and it is alleged that the petitioner has circulated certain video of the victim, has sent certain video of the victim to brothers, and which has been further circulated.
No. The brothers of the victim has.
And
It has been
several
sent to
The brothers of the
the
victim.
victim.
And several others.
The learned counsel has, for the state, has submitted that as per the meeting order, the video has been circulated to, obscene video has been circulated to her brothers to humiliate her.
And some other person.
खाली brothers को ही भेजा। After hearing the learned counsel for the parties and considering the fact that the charge sheet has already been submitted, the petition is directed to be
Item 29, VA 5004 of 2026.
Being rejected, a charge with way to similarly situated granted, but there was one anticipating that is. One VT is there of 3,000 rupees.
I rejected it earlier. Where is that order of rejection?
Is the next 2 minutes. Page 18.
उसमें ना previous order में लिखी है that bail application was earlier withdrawn. उसमें withdrawn.
उसमें withdrawn.
हाँ, उसमें लिखी है ना previously withdrawn. Yes. Where is that order?
18, page 18. Similarly situated vehicles whose prayer was also rejected, but coordinate bench was granted subsequently after finding the charge.
अभी क्या stage है?
The charge frame हुआ है. I have annexed that charge also. Blood your lordship में कहीं.
Charge frame no?
Charge frame wrong. Not. That is January 25 को और he is in custody from August 2025.
He's 126 को.
26 को.
Charge has been framed.
Yes.
He's in custody since
4/8/2025.
stage क्या है बस? आपने impugned order तो लगाया हुआ है 2011 में, 2025 में, 11th month.
But I have stated that I have annexed that charge. It is pending for charge. Pending for evidence.
From where do I get how many witnesses have been examined?
Milord, as per our no witness.
The learned counsel for the petitioner, the impugned order passed in this case is
No witness.
dated 25/11/2025. The office is directed to call for a report with regard
The
to the
report
state
was
of
called in
witness.
this case, my lord. While granting bail, my lord, the report was called. And after that, my lord, bail was granted.
We can't लिखा है report के बारे में.
Call हुआ था उसमें.
कॉल कर लिया जाए
Call for
But
a
it-
report
no
from the
witness has
concerned
been
court
examined.
regarding the state of the case. It has been submitted that the charge has been claimed on 8/1/26.
Yes.
And petitioner is in custody since
21/26 and he is in custody since 4/8/2025.
4/8/2025. ये चार्ज का फ्रेम हुआ है 20/1.
But yes, B6 changes. And there was a victim, therefore you also at that time rejected that. One victim of 3,000 is there.
So antecedent.
One case was there that we have
थोड़ा देर
stated.
Post on 17.
17.
Item 30 DA 5776 of 2026.
Earlier, the pay for bill was rejected. Running order and issued 2 days 1331. In this case, prayer for bill elected on 10/2/25/26.
When is that?
And the charge is already.
Where is the order?
Order is at page 30/31. He has one antecedent. He is collected in the year 2018 years.
Yes, Mr. Tiwari, you are there in this case. When was the last witness produced? When was the last witness produced?
None of the witnesses have been examined. I have stated in my petition.
Yes, Mr. Tiwari, your case.
Paragraph 2.
आप जरा आइए.
Charge has been framed.
His bail application was rejected on 17th of February 26, with the direction to ensure that the witnesses are produced. But the SP has not produced any witness. I will initiate a contempt against him.
Last.
And he has renewed his prayer for bail.
ये
number
verify कर रहे हैं हम
577
लोग, एक लेटर लिखते हैं लोग.
Sorry.
एक लेटर लिखते हैं हम लोग इनको जो
वो
कोर्ट
सारा
का
रिकॉर्ड पे लेके आइए और एसपी से जरा शोकस मंगाइए. इसीलिए आप ही का अपीयरेंस इसमें रिकॉर्ड करेंगे, दूसरे को सुनेंगे नहीं. Because you had appeared on the last date, so you will be bringing on record what all letters you have written, and SP will you seek an explanation from the SP as to why this order has not been complied. Right?
और एक बार स्टेटस देख लेते हैं कुछ हुआ है
देख लीजिए.
उसके बाद
BA number 5776 of 2026. The bail application of the petitioner was rejected earlier in BA number 10608 of 2025 by the order dated 17th of February 2026. However, there was a clear direction by this court that the state was to ensure that the prompt production of witnesses during trial, and the state was, counsel for the state was also directed to communicate the order to the concerned authority. Mr. Salim Kumar Tiwari was the APP in BA number 10608 of 2025, who normally appears in the cases related to cybercrime. He is present in the court. This court has called upon Mr. Salim Kumar Tiwari to explain as to whether to inform this court as to whether appropriate steps were taken to communicate the order of this court, and also explain as to why and also seek instructions and file an affidavit as to why the witnesses were not produced before the court. Office is also directed to call for the entire order sheet from the concerned court right from 17th of February 2026. Post on 24th July.
Item 31 DA 5818 of 2026.
Office is directed to bring the name of Mr. Salim Kumar Tiwari from the side of the opposite party is.
Second layer of regular endorsing. And also kindly see connected to page number 37. Earlier, the petitioner had withdrawn his bail application and endorsing by given authority with the liberty to renew the prayer.
I had said that when this court was not inclined to enlarge the petition, isn't it? I heard you. I was not inclined. When you sought withdrawal, I allowed you.
Yes, sir.
I have applied my mind. I was not inclined to this. So it is as good as reject, as good as an order of rejection. Because I remember, ऐसा हम order तभी लिखते, otherwise नहीं लिखते. What is the fresh ground?
Fresh ground to charge paying endorsing on this charge to 26 endorsing and similar situated coefficient endorsing by
One similar situated coefficient.
Petitioner has no criminal interest in endorsing.
There are two persons, Parvez and Parvez. Right?
No, three.
Sorry.
I three.
There are three petitioners.
Yes,
All the, yes, Niaz.
yes.
Niaz also. He had submitted that he had no criminal antecedent.
Yes.
Do you have any criminal antecedent?
So as per instruction. Earlier I did not know.
Earlier your case was you had withdrawn, no? You have any criminal antecedent or you don't have any?
As per instruction of my client. No.
Where have you mentioned that you have no criminal antecedent? Where have you mentioned?
Yes, sir. Para 15.
इसमें काउंटर फाइल कर दीजिए क्या करें पहले तो विड्रॉ कर The learned counsel for the state is identity with instructions and find a counter affidavit in the state with the reference to the criminal antecedent of the petitioner. Petitioners, each of the petitioners. The counter affidavit should clearly state as to whether any other case has been registered against the petitioner in the state of Jharkhand or in any other state, linking the seized mobile or SIM or the petitioner was the standard of it has been also submitted that by the petitioner that similarly situated poetry Aftab Ansari has been enlarged on bail by this court on the submission that he had no criminal antecedent. The case of the petitioner is on similar. Okay. Post on that request.
Appearance. Item 32, BA 5820.26.
Earlier the paper were rejected bills, that is at page 1819 annexure 2. I have no criminal antecedent bills. I have stated, and one victim is there bills, amount of 49,000, and I'm in custody since
23/8/25 and as many as 8 persons were apprehended by the police. Out of 8 bullets, 7 have been planted with bullets. And I have no criminal history.
इसका जरा order दीजिए. DA number 9921 of 20. 9921 of 20. DA number 9921.
I have annexed the order. That is page 18, annexure 2.
No, I'm not talking about that. Custody बताइए.
I'm in custody since 23/8/25. Having no antecedent, I am stating paragraph 22. There is a recovery of one mobile set without SIM card, one laptop. Charge frame on 3/1/26. I have an extra copy of framing of charge annexure 4. 20 persons have been last in bail. Annexure.
Victim.
One victim is there.
Amount.
Amount of it is 49,494.
क्या बोलता है?
Yes. The para 67 one victim one mobile SIM and a transaction of 4,000 for 29,494. This transaction.
About the legal counsel agreement on behalf of the parties. The legal counsel for the petitioner submits that the इसमें 22 cents क्यों लिखा है?
22 SIM card has been used in the said mobile phone. वो आया है.
And several complaints has been also made.
Complaint is there, but no FIR has been registered. It is a victim, I admitted. I have gone through carefully gone through the diary case diary.
The learned counsel for the petition submits that the bail application of the petition was earlier rejected on 23/26 and bail number 9791 of 2025. And the petitioner is in custody since 23/8/25 and charge has been framed on 3/1/26. The petitioner does not have any criminal antecedents and one victim has been identified. One mobile with no SIM and one laptop is alleged to have been recovered from the possession of the petitioner. He has also submitted that several court-case persons have been enlarged on bail. The learned counsel for the state has opposed the prayer for bail. However, the submissions made by the counsel for the petitioner is not in dispute. After hearing the counsel for the parties and considering the custody of the petitioner and charge having already been framed, and that the petitioner, as stated in paragraph number,
Charge frame was stated in paragraph 7 of my petition.
no antecedent.
No, I think 22.
As stated in paragraph 22 of the bail application, having no criminal antecedent, the petition is directed to be enlarged on bail. The learned court shall call for the antecedent report of the petitioner, and if any antecedent is found, it shall not be repeated.
Item 33 BA 5920/2026.
On two earlier occasions, the petitioner had come before this honorable the first time it was rejected by order dated 18/2/2026. Subsequent to that, the same was withdrawn in the other bail application 3746 of 2026 on 5/5/26. Mobiles 3 in number, some SIM cards 9 in number, and
What is the stage of the case?
the 3 witnesses have been examined out of 10 witnesses. He
When was the last witness examined?
Two of the witnesses we have given, that is on 6th May 2026 and 3rd June 2026. And the third one just 1 week ago, that we have not been able to find. And he is already in jail custody since 6/8/2025.
No antecedent?
There
No
was,
antecedent.
there was one antecedent we have not given, but not cyber case. There was a fight between the Bhuktiyas.
Where have you?
I have not mentioned. Save and except this cyber case, there is no cyber case. And there is not a single victim in this case who has come to say that any money has been
In your
transferred from
earlier
them.
order of rejection, it has been recorded that the victim has also supported the prosecution. It is
That is
mentioned.
not there, because the informant is also there in the evidence which he has
I
given
don't know,
before the
in order dated 18/2/26, it is recorded. Para 6. And once I recorded, I mean it. I must have seen the case diary and recorded it.
In the evidence of the IO, there is nothing of that sort.
I do not think.
PW1 and
You
PW.
cannot say that no victim has come.
Now he is already in jail custody since 6/8/25, and in this case, maximum punishment is of 3 years. Already he has remained in jail for nearly 11 months have already passed. There are 10 witnesses in this case. 3 have been examined.
What do you say on the point of custody? ये witness तो आप produce नहीं कर
There
रहे.
are allegations of organized crime, life conviction, organized crime, 1 to the crime.
Yes. 5 ATMs, bank card.
11112, that is the organized crime.
Merely mentioning it, your lordship.
Charge has been framed. and
Yes, no.
Charge has not been framed.
No, charge has been framed. I have given annexure 3. Please just have a look to the charges.
We will expedite your time.
That was in the first order itself.
I'll ask them. But when was the? That is why I wanted to know that the first witness was produced on 6/5/26.
6/5/26.
इसके पहले कोई witness नहीं
नहीं.
produced.
And we have given. Please just have a look to the position of witness number 1 and all police constables and the sub-inspector.
When was the charge framed?
The charge was framed on 20, I have given the 28/1/26. That is annexure 3. And in the first order that was passed, it was categorically stated, that is at paragraph 8. However, the state is directed to ensure prompt production of the witnesses before the court. That was on 18/2/2026. And thereafter, the first witness has been examined on 6th May 2026.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 6/8/2025 and has one antecedent, but it does not relate to any cyber offense. The charge was framed on 20/1/26. The bail application of the petitioner was rejected on 18/2/26 in DA number 10871 of 2025, and The state was directed to ensure prompt production of witnesses before the court. And a copy of the order was also directed to be communicated to Superintendent of Police Jantara to ensure compliance. He has referred to the first witness who was examined before the court, which was only on the 6th of May 2026. The learned counsel submits that the witnesses have not been promptly produced by the state, and the custody of the petitioner is almost approaching 1 year. The learned counsel for the state has opposed the bail for bail, but has not disputed this fact. The aforesaid facts which has been mentioned by the learned counsel for the petitioner. After hearing the learned counsel for the parties and considering the custody of the petitioner since 6/8/2025, and the petitioner having no criminal antecedent under cybercrime, the petitioner is directed to be enlarged on bail. However, the court would call upon a report from the prosecution and the petitioner, and if any other side, the case relating to cyber offence is found against the petitioner as an antecedent, the petitioner shall not be released on bail.
1 year may be said to be 11 months.
11 months.
Item 34, BSC 024 of 2026.
Rejected. Is in custody since last 1 year. 20-6-25 charge has been framed on 11/12/25, and the first witness has been examined on 10/6/2026. One more fact rejected.
10/6/26.
Yes, 10/6/26. That co-accused that the lordship has rejected, considering that there are 102 FIR against the president. Now, till date, neither the co-accused who has been granted bail has been released, neither the petitioner has been remanded in any case till date, although he is in custody for last more than.
We are not concerned with other cases.
Yes.
We are not concerned, but there are so many cases.
Yes, as per the
Yes.
But till date, not remanded in any case, having no criminal antecedent, as
No
per us.
criminal antecedent. Not remanded does not mean that there is no
Yes,
criminal
that
antecedent.
I have specific stated one thing, that the petitioner has not.
I am not inclined to
No,
it.
no, but
आप अपना acquittal कराइए आप.
but he
वैसे नहीं, I'm seeing the acquittal orders which are coming up. All the Caesar witnesses, which are all police officials,
yes.
they are virtually turning hostile. Because when they are asked in the cross examination, कौन सा SIM मिला, कौन सा फोन मिला, उसका EMI नंबर क्या है, जैसे मुझे नहीं पता, हो गया कहानी खत्म.
एक ही चीज पर हम
तो आप acquittal में ज़्यादा focus करिए, आप you will able to get yourself acquitted. That is why there is mass scale. There is mass scale cyber fraud. There is mass scale acquittal. ये दोनों चीज चल रहा है झारखंड में.
I custody not only एक चीज खाली.
आपका देखिए, this is not a case where I can grant you bail on the point of custody.
One more point. Late the trial court.
After earlier rejection order था.
Yes, sir.
It must be there in the file. You must have annexed it.
By mistake it was not annexed.
By mistake मतलब?
मैं drafting.
ये defect free कैसे हो गया?
Annex ये करने का ये जरूरी नहीं.
Annex करना जरूरी नहीं.
But I have brought that order.
I'm grateful to you.
No, only one thing. Not grateful.
I am grateful.
No, Lord, that is with me, Lord. Only one factor is saying, Lord, that he is in custody for more than 1 year. Lord, your Lordship may consider his custody period. Lord is a young boy.
Not the case. Young होके ज़्यादा case.
कॉलेज में एडमिशन लिए थे.
कोई बात नहीं.
Lord, in direction भी एक time में भी frame.
Lord, लेते जेल में.
Lord, time may be framed. Lord, if you.
It's a case of organized crime. I'm not.
Lord, organized crime. Lord, it is stated, Lord. Lord, but till Lord, a time may be framed. Lord, only I am requesting, Lord, because they
Time frame नहीं करेंगे.
expedite क्योंकि मिलोट the charge has been framed मिलोट on 11/12/25 और 6 महीना में 1 witness
कितने विटनेस हैं?
मिलोट there are some
बताइए।
that I am saying मिलोट because I was verifying the record of the lower court मिलोट online it said the last first witness has been examined on 10/6/2026 that
एक चीज और है, जो कोर्ट में डेट पड़ता है, इस तरह के ऑर्डर्स जहाँ पे प्रॉम्प्ट प्रोडक्शन ऑफ विटनेसेस का ऑर्डर है, योर एपीपी शुड इंश्योर दैट कि शॉर्ट डेट पड़े। आप 2-2 महीने का डेट लीजिएगा
नहीं
तो क्या होगा?
शॉर्ट डेट पड़ रहा है द ऑर्डर शीट ऑल्सो
वाले
Get it?
तो एविडेंस पे हो जाता है, पहले नहीं लेट होता था, अभी तो तक जो एविडेंस पे चलता है उसमें बहुत ज्यादा लंबा डेट
लंबा डेट।
अब पहले
नहीं ज्यादा लंबा
हाँ
टाइम
बताइए
जाएगा
ना, टोटल विटनेस यू जस्ट टेल मी हाउ मेनी विटनेसेस आर देयर?
चार्जशीट तो नहीं है मेरे पास
पता ही नहीं है।
नहीं चार्जशीट का कॉपी नहीं एंटायर ऑर्डर शीट इज विद मी
You tell me how many witnesses are
ये
there?
चार्जशीट कॉपी इज नॉट विद मी विल लेट टू पासवर्ड
No, pass over का
हम
कुछ
पता
काम
करके
नहीं।
बता देंगे नेक्स्ट
कोई बात।
चार्जशीट कॉपी निकाल लेते हैं
Heard the learned counsel appearing on behalf of the parties. The bail application of the petition was rejected earlier in bail number 42 of 2026 by the order dated 9/4/2026. The learned counsel for the petitioner submits that he has renewed his prayer for bail on account of his custody since 26/2025. The charge was framed on 11/5/25 and the first witness has been examined only on 10/6/2026. The learned counsel for the state has opposed a prayer for bail and has submitted that it is a case of organized crime. The rejection order, the earlier rejection order reveals that there are 102 FIRs lodged and 2690 complaints, and there are altogether rupees 9.99 crore which has been defrauded. After hearing the counsel for the parties and considering the seriousness of allegation against the petitioner, this court is not inclined to enlarge the petitioner on bail. However, there can be no reason for non-production of witnesses by the prosecution before the court. The state is directed to ensure that the witnesses are promptly produced before the court. The counsel for the state is directed to communicate this order to SP of the concerned district and to the director of execution. इस केस में आना नहीं चाहिए कि विटनेस नहीं आता, ठीक है? ये ग्राउंड दिस केस डज नॉट डिजर्व दैट। आपको जो करना है ट्यूटल करा दीजिए, नो प्रॉब्लम। You get if you are seeing the orders of acquittal. Your Caesar witnesses, they are all police witnesses. कोई अलग से इंडिपेंडेंट विटनेस नहीं है, and they are as good as hostile. रादर क्रॉस एग्जामिनेशन में बोल रहे हैं कि कोई विक्टिम नहीं मिला, जबकि ऑर्डर में लिखा हुआ है रिजेक्शन ऑर्डर में that there was a victim.
Even the statement, the seizure was prepared in the police station. They signed in the police station. All these facts they are stating not in the court.
Trial में तो सब hostile, as good as hostile.
Not only
They are saying SIM number नहीं पता, मोबाइल का IMEI नंबर नहीं, हो गया खत्म, क्रॉस में खत्म, सब खत्म।
IMI तो हम लोग भी मोबाइल जो चलाते हैं लॉर्ड से या तो जब
नहीं
सिम
पता,
चोरी
लेकिन
नहीं जब चोरी होता है FIR करने जाते हैं तो हम लोग IMI
सीजर लिस्ट तो बोलेगा ना,
हाँ, सीजर लिस्ट बोलेगा।
उसमें लिखा हुआ है, बोलेगा कि सीजर लिस्ट में मेंशन है, इतना तो बोलेगा, या वो भी नहीं
तो
बोलेगा।
IMI बोलेंगे।
देख मेमोरी से थोड़ी चलेगा, जो रिकॉर्ड
नहीं ऐसे कौन सी बता रहे हैं, हम लोग जो मोबाइल यूज करते हैं जब सिम भुलाता है तो हम लोग IMI खोदवाते हैं कैसे उसको
आजकल 90% लोगों को अपना मोबाइल नंबर याद नहीं रहता, they don't remember their number. I remember only one number, जो दूसरा फोन है आपको उसका नंबर नहीं पता। ये सब IMI
तो complicated
some direction for expedite.
expedition कर देती
एक आइटम 30 में ऑर्डर हुआ था, वो एक्चुअली कंक्लूड द ट्रायल का कम्युनिकेशन करना
था, वो हो गया।
तो वो जो ऑर्डर किया गया था हमने वेरीफाई कर दिया, बैठे बैठे हम वेरीफाई कर, वो मेरा जो हम लोग का पोर्टल होता है उसमें हम लोग का कम्युनिकेशन, हमारा कम्युनिकेशन, और कैसे मेरे चलते लैग हुआ, मेरे ऑफिस के चलते हुआ या कैसे हुआ,
वो आएगा
तो वो एसपी से मांगा गया कि व्हाट इज द कम्युनिकेशन टू द पब्लिक।
he has to explain, हम तो ऑर्डर किया, हम क्या-क्या ऑर्डर किया हमको याद नहीं।
तो एक्चुअली मेरा कम्युनिकेशन नहीं है, एक्चुअली हम लोग कुछ किसी दिन एब्सेंट होता है या हमारे दूसरे एपीपी मेरे बदले अपीयर होते हैं, तो कुछ कभी-कभी हम लोग का मिस्टेक।
लेकिन आपका अपीयरेंस ऐसे लिए प्रॉक्सी इस कोर्ट में नहीं चलता।
नहीं प्रॉक्सी नहीं, जैसे कभी
जैसे कि
छुट्टी
आप
में
नहीं रहेंगे ना, तो हम दूसरे का अपीयरेंस जो रहेगा उसी का
नहीं,
अपीयरेंस
हमारा कैसे हो किस कारण से वो उसको हम लोग बहुत
let us see, let the counter come, we'll see.
Item 35.
Because you see,
एक्चुअली हम ही वेरीफाई करते रहते हैं कि हमारा भी कहीं कहीं हो रहा है कि नहीं हो रहा है
counter.
Item 35, DA6132 of 2026.
Earlier, the paper fee was rejected. On the ground that he has the transaction minutes. Actually, his father was the contractor, and in the last year he died, and he was working with his uncle Millers as the coffee Millers.
Where is the order of rejection?
That is at page 37. He has no victim, no antecedent, only there is a transaction minutes.
Of 61 lakhs?
Yes. I admitted Millers. Actually
admitted मत
इसको हम admit कर रहे हैं क्योंकि आया हुआ है, लेकिन इसका explanation है हमारे पास.
बताइए 61
इसका
lakhs.
explanation यही है कि इनके father contractor थे, अभी इनके अंकल काम कर रहे हैं, उनके अंडर ये काम करते हैं और यही पेमेंट वगैरह सारा पेमेंट वगैरह करते हैं, इनके अकाउंट में हुआ, लेकिन कोई इलीगल ट्रांजैक्शन नहीं है, कोई विक्टिम नहीं है.
इतना बड़ा अमाउंट का किसने आपको देने है?
इसमें
उसके अलावा आपको क्या चाहिए बताइए?
इसके अलावा जो चार्ज फ्रेम हो गया है 13/3/26 को, none of the witnesses have been examined till date minutes.
13/3/26.
Yes, minutes. After rejection, I'm in custody since 26/8/25. He has no criminal history.
26.
26/8/25. He has no criminal antecedent. I have studied paragraph 22.
चार्ज फ्रेम हुआ 13/3 को ना?
Yes.
और ये जो ऑर्डर है रिजेक्शन का 17/2/26.
Yes, please.
तो उसके पहले तो विटनेस नहीं प्रोड्यूस हो सकते हैं बिना चार्ज.
उसके बाद, लेकिन उसके बाद 4 महीना हो गया, इसमें एक स्टेटस मंगा लिया जाएगा, क्योंकि इसमें एक का स्टेटस मांगा गया, एक कोई कि उसका इसमें कॉल पर हुआ है. ये है सीरियल नंबर 30 मिनट्स, बीए नंबर
6132 नहीं, उसके साथ ही बीए नंबर 6132 ऑफ 2026.
इसको अलग से इस पे देख लिया जाए, क्योंकि 4 महीना हो गया.
और the learned counsel submitting on behalf of the parties.
Counsel
for the petition.
Kindly consider minutes.
application.
May I submit one thing minutes? Only one thing minutes. Kindly consider minutes. एक बार हो तो एक बार इसमें एक चीज देख लिया जाए. नहीं अमाउंट नहीं, तो मेरा बस इतना ही कहना है. काइंडली सी मिनट्स इन साइबर क्राइम केसेस मिनट्स विक्टिम होता है, विक्टिम का स्टेटमेंट रिकॉर्ड किया जाता है, और कोई एक्यूज्ड के खिलाफ विक्टिम आया है, उसका स्टेटमेंट है, मेरे खिलाफ कोई विक्टिम नहीं.
Through your account. Explain. Did you file any FIR? Did you? My account has been fraudulently
This is actually this is the valid transaction minutes, a genuine transaction. This minutes. I will file the same minutes. I will file a supplementary minutes.
Given to whom? Where did this money go?
Minutes. My uncle is a contractor. I am working
This money
under.
has come from which place?
I will explain it minutes. I may be a week time may be granted minutes. I will explain it minutes. My
ये आराम से सुन के आपको कभी सुनने में कमी की है?
नहीं, कभी नहीं.
पूरा केस डायरी देख के ऑर्डर करते हैं, इसलिए हमको एक एक लाइन पता है. Whatever I have written it very consciously after seeing the case diary, after hearing both the parties.
एक सबमिशन, लास्ट सबमिशन नोटिस, एक हमको बस मौका दिया जाए, उसको हम एक्सप्लेन करते हैं, उसके बाद जो भी ऑर्डर होगा जरूर
हम इस पर अपील में नहीं बैठे हैं ना.
within a week minutes I will file it minutes. After a week minutes our short date will be.
हम आपको सुन लिए हैं, आप थोड़ा वेट. BA number 11517 of 2025. Sorry. BA number 6132 of 2026. The learned counsel for the petitioner submits that the bail application of the petitioner was rejected earlier in BA number 11517 of 2025 on 17th of February 2026. And in that case, the state was directed to ensure prompt production of witnesses during trial. He submits that thereafter the charge was framed only on 30/3/2026. And only one witness has been but no witness has been examined so far. And as per the impugned order, summons have been issued on 1/4/2026. The impugned order is dated 16/4/2026. After hearing, the learned counsel for the state has opposed the prayer for bail and they submitted that The allegation, the earlier order clearly reveals that there is an allegation that numerous transactions and WhatsApp chats have been mentioned in the case diary during the period from 26/8/24 to 26/8/25, and an amount of rupees 61,40,374 has been deposited through various UPI transactions. And during this period, 61,30,820 was also withdrawn. The bank account belongs to the petitioner. After hearing the counsel for the parties and considering the huge amount involved in cyber offence alleged to have been committed against the petitioner and the bail application of the petitioner having been rejected on merits earlier, this court is not inclined to enlarge the petition on merit against rejection.
Under heading for admission, item 36, WPS 837 of 2007.
This petition. What is this case of 2007? Is it an admitted case?
Not an admitted case. It was admission. It was assigned to your lordship because it was listed before only.
compromise हो गया
Compromise.
उसमें ऑर्डर नंबर 9 लिखा जाए ये एडजॉर्न फॉर सैनिटाइज हुआ था
during the pendency of the SLP.
हाँ सुप्रीम कोर्ट एक पार्टी गया था सिमिलर केस था उसके आधार पे झालसा में डायरेक्टर और पिटिशनर के बीच में एक कंप्रोमाइज हो गया था जो वो डायरेक्टर अभी उनको एक्सटेंशन नहीं मिला तो चले गए हैं और उनके बीच में ये हुआ था इनको जानकारी दी गई थी हम बोले थे कि हमको लिख के दे दीजिए तो बोले थे देंगे इसी दौरान उनका वो
पिटिशनर को सुनने तो दीजिए क्या बोलना
नंबर हम जानकारी केवल हम
do you want adjournment or you want to argue?
So far the compromise is concerned, I don't have any paper with regard to this one. It is a very old case.
What is the matter?
Matter relates to once promotion was granted on a particular scale of pay of rupees 55,500, 9,000. That has been cancelled by Annexure 8, and that cancellation order is under check. It was granted on Annexure 5, page 32. Page 32.
So what is the why the matter till travel till the Supreme Court?
That is another one. That is
इसमें सारा ऑर्डर लगा हुआ है SLP का ऑर्डर
बता रहे हैं Annexure 1
का ऑर्डर
you see just see the previous order note Annexure 2, that is WPS number 174 of 2004, page 25. That travel up to the Honorable Supreme. Court, and this was decided here by the Honorable Single Bench on 12th of July.
Sani, he is saying that there has been some complaints and he has to seek instructions on that.
That is,
If there is any
supplementary counter may be filed.
You have a respondent number?
All the
respondents. The learned counsel for the respondents submits that there has been certain out of court settlement. He prays for some time to bring it on record.
3 weeks में
सेटलमेंट अभी करना है कि हो चुका है करना है कि हो चुका है करना है तो हम आपको 6 वीक्स देंगे अगर हो चुका है तो 2 हफ्ता बहुत
ठीक है 2 हफ्ता
Respondent number 3 to 6.
2007 का केस मेरे
Respondent number
3 to 6.
Respondent number 3 to 6. Post on 17. Post on 24. The supplementary counter affidavit relating to settlement be placed on record latest by 21st of July.
Item 37, WPS 4563 of 2013, along with item 38.
The first one, that is serial number 37, pertains to the petitioner who is principal of Project Girls School Kalchari, and serial number 38 pertains to
Project Girls School. The story is not yet over.
This is a different story, however, here I'm pressing
too much. Why
is
already
already
come to
decided
me?
this issue.
I've already
Yes,
decided.
Your Ladyship, this case is slightly different from the other matters.
But why WPS is before me? Assigned.
Assigned.
Yes, Your Ladyship. It was listed before code number 3 earlier, and then it was sent over here.
LPA is also there. It was decided in that LPA only.
This is a different matter, Your Ladyship. In fact, if I may, Ladyship, point out para 82 of that LPA, it states the issue that the block, the projects they are seeking relief for itself was closed back then. And that has been observed in the LPA. Your Ladyship, that is why I'm pressing serial number 38 and not 37.
You have got the respondent number?
Respondent number 1, 2, 3, 4. In serial number 36.
For the state?
Yes.
In both the cases?
No, only 37. Your Ladyship, I'm pressing.
Both has the same issue.
Your Ladyship, 38 is with respect to only one petitioner, Raman Kumari, who was employed as a teacher, assistant teacher for economics in the said school of Project Girls School Kalchari. And she has not been paid any of her dues despite serving there for 33 years until her retirement. And Your Ladyship, there are documents over 10 annexures that clearly states that all the government authorities have recognized this school as Project Girls School. And in the counter affidavit, which is for year 2018, the only statement that
file your written submissions. Then I will hear you. I will hear you. You file your written submissions. I will hear both. Right? She says that it is covered by which judgment?
This is LPA 138 of 2019. And please.
LPA 138, right?
Yes.
That's sorry. The learned counsel for the respondents. In WPS number?
Yes, number 4563.
4563. I submitted that the present case is fully covered by LPA number 138 of 2019. Nobody asked for the respondents in WPS number 773 of 2014. Equally, the counsel for the petitioners in both the cases is present. The submission of the respondent counsel is being disputed by the counsel for the petition. The counsels are directed to submit their written submissions. How much time will it take? By 17th, post on 24th. Right? You inform the other counsel also.
Yes.
I think one counsel will be sufficient for both the cases.
Yes,
why different counsel?
The issue is more or less the same.
But she is not assigned that much.
Yes,
This Project Girls School matter is not yet over, I am surprised.
Item
But
39.
I filed a SLP against that. Not yet. That order, this review order.
No, it should be filing a fresh petition.
Appearance दीजिए आप लोग. Item 39 WPC 1480/2019.
This is also assigned one.
कहाँ से सब assigned matters आ गए हैं?
Book number 8 में था जो उसमें स्टेट के गवर्नमेंट में थे तो 3 ही तो इसलिए
क्या मैटर?
शॉर्ट में बता annexure 22 and 22(1) by 1 is under challenge, by which the grant in aid has been refused to the institution, the petitioner school, on a ground that it does not fulfill the criteria in terms of 1980 circular, which says there must be a trained teacher in the school, then only the grant is to be paid. That is not there in 80, 76, 2011 and 2014 circular.
That condition is not there.
Not there. That there speaks, that circular speaks, if there is no trained teacher available, then untrained teacher can be appointed, but subject that will be given, that salary will be one scale less.
Your school is a minority school.
It's a minority school.
What kind of minority? Linguistic or linguistic or religious?
Madrasa hai ye. Lordship may come directly to.
What is the name of the school? And why this individual person has filed this?
He is the secretary, Lordship. Secretary has filed.
You have been given recognition.
Lordship, yes, I am recognized. Lordship will directly come to earlier round of litigation. Lordship will get everything. Page 111. All fact will come, Lordship, in page 111. Earlier round of litigation, Honorable Court has directed to
All
act.
the pleadings are complete.
All the pleadings are complete.
Are you ready? Should I hear it?
Actually, my senior has to argue this matter.
सुन ले। अब आपको सुनने के 15 मिनट बाद ही बोलेंगे adjourn it for my seniors. Who is your senior?
With less is the chief.
So it can't be like this, no? It can't be like this. You have not read the brief and your senior is not. Tell me what is the matter. Yes, I'm asking you.
Percent his application is rejected by Annexure 22 by 1, page number 123.
What is the matter? Give me the background. What is the matter about?
Petitioner is the secretary of Madrasa. Lordship, he has filed an application seeking a grant for the Madrasa. Advertisement was issued by the respondent, whereby it was said and application was invited for a grant in date for a Madrasa. Thereafter, Lordship, petitioner has applied. An inspection was carried out by Lordship Annexure.
I have carried out the inspection.
Sorry, Lordship.
I have not carried out the inspection. You say the inspection was carried out by
Jharkhand Academic Council, inquiry was conducted also.
Okay.
It is at page number 115.
You say that these circulars, the condition under these circulars are not satisfied.
Yes, Lordship.
Where are those circulars?
Lordship, kindly, it is in.
And which condition is not satisfied?
It is in the written petition itself, Lordship. Page number 45.
45.
Yes, Lordship.
Yes.
And 46 is the Lordship. In 45, Lordship, there is a classification of Madrasa.
45. This is dated 29th of November.
1980 also. In the left hand side, there is a classification of Madrasa. Column number 1 also. Column. Wherein there is first is Jharkhand, and the petitioners comes in category Kha. It is Vastania.
Okay, he comes in
Vastania. Thereafter, Lordship, in the next page, the requirement of teacher in Vastania is mentioned in clause 3. It says शिक्षक प्रधान मौलवी एक होना चाहिए, मौलवी एक होना चाहिए और कहानियां एक होना चाहिए। दूसरा प्रशिक्षित इंटरमीडिएट एक और प्रशिक्षित मैट्रिक एक।
नीचे प्रधान
मौलवी
सो इनके और से प्रशिक्षित इंटरमीडिएट जो है वो नहीं है।
और क्या
सी द इंस्पेक्शन रिपोर्ट
और क्या नहीं
बस उसी
ये बस इसी का डिस्प्ले। You have referred to 3 circulars.
एक नेक्स्ट पेज खाली देख लीजिए।
This is one.
Second is at page 66 and third at page 106.
There are three circulars.
Yes,
right?
that I have annexed.
This is 29/11/80. We have seen.
Yes, that is annexure 1, annexure 30, page 66.
Page 66. Annexure 1. Annexure
18,
13.
29/11/80. Annexure 1.
Annexure 1 is
29/11/80.
29/11/80. And annexure 13.
14/11/2011.
14/11/2011.
And annexure 17 is 18/10/14.
29/11/80. Yes, what is there in annexure 13? Yes, please tell me. Which clause they do not satisfy?
What's it in para number 5? Subclause झारखंड राज्य अंतर्गत संचालित एवं अविभाजित बिहार राज्य के समय से बिहार राज्य मदरसा शिक्षा बोर्ड द्वारा निबंधित मदरसे
That's why it has to be compliant.
आपके 1980 इसके बाद उसी के बारे में
It is referring to basic thing is 1980.
Yes, basic.
That is being referred to all others.
Yes,
Yes, you tell.
Got it.
Do you satisfy?
I will satisfy.
Firstly, I want to know.
Yes.
Do you come within the category number K?
Yes, yes.
There is no dispute.
No dispute. No dispute. Now, also comes to page, next page, clause 4 of annexure 1.
Clause 4 of annexure 1. Yes.
Page type copy is at page 46A.
Yes, I can read it.
Para 4, clause 5 release. कितनी आधुनिक विषय के परीक्षित उम्मीदवारों की अनुपलब्धता की स्थिति में अपरिचित उम्मीदवारों की नियुक्ति संभव हो सकेगी, किंतु वैसी दशा में उन्हें एक श्रेणी नीचे की योग्यता के शिक्षकों का वेतन तय होगा. So this circular nowhere says, which my learned friend has read, says क्या होगा, but where is the mandatory condition that one must have a trained? There is no such mandatory provision saying there must be trained. I will show with the 177 circular also, which says the appointment ought to have been made by the madrasa board only. Anyways, this clearly says if and they have accepted in the counter affidavit. Only all are trained, but only 2 are untrained. I will read the paragraph of counter affidavit.
See, intermediate is only one teacher.
One
required.
post, yes.
Only one post.
One post, only one, and all are trained. That is not disputed. They have themselves admitted in the counter affidavit.
All are trained means all are intertrained.
Inter-trained and मौलवी सब है, एक है सबका ट्रेंड नहीं होगा. कुछ प्रधान मौलवी है जो अनट्रेंड होंगे. मौलवी उन लोग अपना अलग से क्वालिफिकेशन होता है. उदिया फिर फिकानिया है, हाफिज है, एक परिचित इंटरमीडिएट होना चाहिए. That I will come. And clause 4 clearly speaks for class 1 to 12. वो देख लॉजिक में ऐसी clause 4 1 to 12 में including my school is 1 to 8. Even for 1 to 12 it says that if trained teacher is not available, then untrained can be appointed, subject that they will get the lesser one scale less than the trained teacher.
Read the
Lordship?
read the impugn order.
Yes, Lordship. Impugn order is at page
123.
This backup is also important. 121.
Wow, 121 notes.
We did it later.
ये अर्लियर ऑर्डर ऑफ लिटिगेशन का पूरा दिया गया है and court has directed to act in terms of section 6 of 2004 act. 2004 act is also does not speaks about the mandatory provision of having a trained teacher. That also is there. And they are trying to amend the act by their own circular, which also does not speak mandatory to have a trained teacher. That is all. Lordship में निर्णय जो है page 122.
झारखंड अध्ययन परिषद रांची के पत्रांक सचिव सच के द्वारा मदरसा सुमनिया गोरिया कर्मा हजारीबाग की प्रस्वीकृत के लिए अनुसूचित प्रस्ताव एवं त्रुटियां निर्णायक प्रतिवेदन और विभागीय अधिसूचना 3/12/15 के आलोक में गठित समिति के द्वारा मदरसा की प्रस्वीकृत के लिए निर्धारित संकल्प 29/11/80 के अनुसार समीक्षा की गई। समीक्षा के क्रम में विषयांकित मदरसा का संकल्प 29/11/80 के तहत शिक्षण एवं शिक्षकों स्टाफ के निर्धारित शिक्षा इंटरमीडिएट एवं परीक्षित मैट्रिक की अर्हता के स्थान पर अपरिचित आईएससी अपरिचित आईए शिक्षा पाए गए, जिसके कारण मदरसा सुमनिया गोरिया कर्मा हजारीबाग प्रस्वीकृति के लिए निर्धारित सभी शर्तें को पूरा नहीं करते हैं। अतः समिति के समसम्मत निर्णय है कि प्रस्तुत मदरसा की प्रस्वीकृति की अनुशंसा नहीं की जाए। Which term and condition has not been followed? They have not said. Simply only they say annexure 1 has not been followed. Which term and condition? Then the original UP law after this annexure 22/1 at page 123.
That is a follow-up.
Follow-up. The same line, something, the same, almost the same thing.
What do you say? What do you say?
What's it kindly see page number 119. 119. This is the position of teachers in the school laws.
Yes.
Now see the first teacher.
So before that, I want to know which clause is not being violated. Only clause 4. That's it. What do you want to show from here?
The first teacher is Muhammad Kabir Hussain. His Saxonic Yogyata is Haji. He also known for section. Second one is he's also Haji. Third one is Alim. Fourth one is Hafiz. Now fifth one is ISC. He is upper section. Sixth one is IA. He is also upper section.
Fifth and sixth are प्रशिक्षित. From where do I get this?
In अभ्युक्ति में लिखा
अच्छा,
है. So there is no trained teacher.
You see, you say that there is no trained teacher. But your circular says that if there is no trained teacher available, you can have teacher, but the pay scale would be of a lower scale. So when there is no requirement of a trained teacher, then how can you reject their claim on the basis that they are not? Show me that they are violating the circular of 19.
In 1980 itself, it is written for 6th intermediate.
उसके नीचे? This explanation we will not read.
Clause 2.
ये टिप्पणी आधुनिक विषय. What is this आधुनिक विषय? What is this आधुनिक विषय?
आधुनिक विषय के प्रशिक्षित उम्मीदवार की अनुप्रयोगता
What is आधुनिक विषय? The core dispute involved in this case is as to whether the petitioner satisfies the requirement in terms of Annexure 1, which is dated 29th of November 1980. During the course of arguments, the learned counsel for the petitioner has submitted that the school of the petitioner falls under clause 1 within bracket K, and as per the said clause, and further as per clause 3, there is a requirement of 1 intermediate trained teacher and 1 matric trained teacher. But as per the note appended to the circular, it has been mentioned that in absence of a trained teacher, another teacher could be appointed whose position would be one step lower. During the course of argument, it is not clear as to what does आधुनिक विषय refer to in this circular. The learned counsel for the state is directed to file supplementary affidavit explaining this position. यादुनी विषय क्या है? File it.
पैरा 6 अच्छा ठीक हुआ पैरा 6 में हम एक चीज दिखलाना चाह रहे थे जो खुद इन लोग एक्सेप्ट किए लास्ट लाइन है कि the DSC Hazaribagh reported that the Madrasa Sumania Methodist School where all 6 posts are filled up, but there is working in last 2 posts are not filled. The all teachers are there who's working. It's okay. Only for 2 you are not.
See, we are not clear how this Adhunik Vishay is referring to what.
Google Translate किए हैं अभी. वो ठीक है आप जो मान रहे हो.
Google Translate से हम लोग चलेंगे क्या?
नहीं हम बोल रहे हम जो किए हैं बता रहे हैं. हम आप जो एफिडेविट मांगी उसमें हम बोल रहे हैं.
It is not clear what is it referring to. How much time do you need?
2 minutes.
Post on 17. The affidavit should be filed with 15. Let me see. I think this circular is maybe you have something.
As per the last order of the Honorable Court, they have conducted the inquiry by the judge, and it was that all report and inquiry report is that everything was found okay in terms of medicine.
You'll see that. There is no trained teacher in your school as they are saying.
And they have to demonstrate before the lawsuit. Where is the mandatory requirement?
You will see that.
Item 40 content 669 of 2023.
This question applied. Content civil 669 of 23. Counsel for the parties submit that the order passed by this court has been complied. Accordingly, this court is not inclined to enlarge to proceed further in this content.
Item 41 content civil 873 of 2025.
Yes, petitioner.
The last order, the date of increment has been amended.
Amended?
Yes, they have
Done. Okay, आपका काम drop कर दें.
अभी
You have filed a supplementary affidavit.
yes. There are university.
A supplementary show cause has been filed on behalf of opposite party number 1. कहाँ लिखे हैं? Where is it? Wherein it has been mentioned.
Annexure 8, page number 10, they have filed.
Wherein annexure A has been, wherein as per annexure A, the date of next increment mentioned in the order passed by the authority as 1/7 has been directed to be read as 1/7/2006 instead of 1/7/2016. The learned counsel for the opposite party state has submitted that the error, typographical error has been rectified. Up on who will pay? The learned counsel for the university submits that needful will be done by the university and admissible amount will be credited in the account of the institution. He has also submitted that now there is no impediment in complying the order of the school. When do I post it?
After 2 weeks.
Post on 24th. Compliance report of the university by 27.
Item 42 content
Details
civil
भी दे दें under which head they are paying your lordship क्योंकि widow ladies को बहुत सारा टाइम मिला नहीं है बीच में कुछ अमाउंट ये पे करते चले गए हैं तो वो कैलकुलेट करने में फिर प्रॉब्लम हो जाएगी तो एक under which head they are paying
Along with the calculation sheet.
Item 42 content civil 1002 of 2025.
Who is there?
Leadership, I am appearing in this matter. Leadership order has not been complied with. If I may bring a leadership's attention to order dated 1st May 2026 edition.
Yes, I am aware of this. What happened in LPA?
LPA is listed for 17th August, Your Lordship. Earlier it was fixed for 30th June. So this contempt case is listed for Your Lordship.
Did you file this affidavit?
No, ladyship.
Have you complied this order? You have to file an affidavit, no?
Your Lordship, kindly see the order dated 8th May 2026, Your Lordship.
It was submitted that year, it has not been complied.
Your Lordship,
If I may submit,
kindly
ladyship.
para 3, Your Lordship, para 3 of order dated 8th May 2000. This the learned ASI are waiting for the opposite party 6 at.
No, you will not read para 2.
Yes, yes. Supplementary affidavit has Shokas has already been filed on.
There is nothing to show that the opposite party has taken any steps in the matter of recognition of various unions.
Yes, on the supplementary show cause it has come, Your Lordship, that the recognition has been extended for the 1 year wide effect from 19/7/2025.
You see, you were supposed to recognize the unions.
Yes, Your
one by one. How many unions have you recognized? This is what I want to know.
Yes.
Leadership knows that process is not even started.
Yes,
leadership.
what are you doing?
Your Lordship, there is some time will be given. I have taken steps.
Leadership, if I may submit, leadership, they have been taking time after time this month or two in leadership, and the process is not even
Who
started.
is the person who is unable to understand this order? You ask him to be here. We'll make him understand. Maybe there is some communication gap between you and your authority.
1 week time may be given, Your Lordship.
1 week will be sufficient.
No, Your Lordship. 1 week is not sufficient.
When you deal of Peter, we know.
3 weeks time may be given, Your Lordship.
But the point is that there is no stay from the NPA. You are not expediting, you are not mentioning, you are not doing anything. Right?
No, Your Lordship, I have listened this NPA, Your Lordship.
No, we are not bothered about it. There is no stay order.
Yes, there is no stay order.
There is no stay order.
Yes, Your Lordship.
Now,
May submit the honorable
it was
Supreme
your
Court also taken
case.
a very strict stance, leadership, on this. That judgment, pendency of an NPA leadership cannot be a paramount for them not complying with your leadership's order.
you see, in the name of taking steps for recognition,
Yes, Your Lordship.
right, you have been extending the period from time to time.
And all facility has been given, Your Lordship.
We don't bother about the facility, they are not beggars.
Leadership, no facility is being given to us,
We
leadership.
don't
That
bother
is again
about
false submission, leadership.
They
Nothing
are-
is being given to us. We are not even being allowed
They
to
have a right
participate
to
in any process of
association.
figure leadership.
How will you take that right from them?
And leadership, they have found a very novel way of hoodwinking your leadership's order. Leadership is that they have been granting extensions.
That is
of
why,
earlier
in the name
recognition
of
leadership.
recognition, granting recognition one after another, right? You have been taking time, and you say that this requires a process. So I want to know that in this process, how much has been done?
Yes, Your Lordship. Your Lordship, 2 weeks time may be given, Your Lordship. I will file the supplementary shows, Your Lordship, explaining all the things, Your Lordship.
Now Madras High Court has already followed this order. That order has been challenged.
I have no knowledge about this.
You have no knowledge about anything. You have taken the court for a right.
No, Your Lordship, because LPA is pending, Your Lordship, and this.
So
was
what should I
also-
do? LPA is pending. It is your stand that you are giving extension from time to time. And you are recognizing in the name of recognition. Where is not even one association has been recognized so far?
What the least
Leadership,
of
if I may
the
submit in order dated 1st May leadership, it has been recorded in the second paragraph itself, leadership, that it has been submitted by the Learned Council for Union of India, that the verification process is going on. And yet leadership, after passage of more than 2 months since that order, there is nothing on record to show that the verification process has even begun, leadership.
The Learned Council for the petitioner has submitted that the respondents have been filing affidavit before this court, stating that the verification process is going on, but no material has been placed on record to substantiate such a standing, correct? He submits that the order dated 8th of May 26 has not yet been complied.
First May, Leadership, 1st May 26.
1st May 26, read with 8th of May 26.
Yes.
Counsel for the respondent.
Your Lordship, supplementary show cause has been filed, Your Lordship, as per para 2, Your Lordship. Supplementary show cause by order dated 1/5/2026 has not been complied in letter and spirit.
That's right.
I have filed the supplementary show cause.
Madam, if you do not want to file anything more, I will hear you on whatever you are filing.
No, Your Lordship, I will file a supplementary show cause, Your Lordship. 2 weeks time we will be.
Post on 17th. The supplementary show cause be filed by 15th. Yes, madam, you have a case?
I want to mention.
No, we'll do all the cases. Don't worry. I'm here. Anybody, it's already past 4:30. Anybody who is not present, that case will be adjourned. But anybody who wants to do the case, they will.
Serial number 46.
Just hold on, I'm not rising right now.
Leadership, it may be indicated that it is the last chance, Leadership.
You just hold on.
Obliging.
Item 43 wrongly listed. Item 44 contempt civil 224 of 2026.
Other side nahi hai. Next Friday, automatic debt. Next.
Item 45 CNP 505 of 2026.
Next Friday. No orders need to be drawn. After 4:30, we do not draw orders. Next.
Item 46 contempt civil 513 of 2026.
Order has been complied.
Mr. Sumit.
Okay, next Friday.
Next Friday.
Item 47 CNP 577 of 2026.
Restoration of
second
appeal. Notice has to go.
Non-prosecution.
Sorry?
Non-prosecution date.
Notice still has to go. Second appeal ऐसे नहीं restore होता है sir. It is not like that. I will not restore second appeal. Issue notice to the opposite parties through the concerned police station, for which requisites will be filed within a week. Post this case on 31st, awaiting service.
Item 48 BA 590 of 2026 and along with 49.
Then
Item 50 CRNP 1918 of 2026.
May please, Your Leadership. Leadership, I have applied for modification of bail order
May be
dated.
posted next week. Mr. Sumit Garodia is the counsel for ACB.
It's a short point, Your Leadership, and there's an urgency in the matter. I have to travel on the 22nd of July. It's my son's graduation
Also,
ceremony.
we will be filing counter if it were 8th period. Take down next Friday.
Your Leadership is issuing notice.
I'll ask you to file a counter.
Your Leadership.
If they have any objection, I'm sure that if it is a genuine matter, they will
We'll
have
file.
no objection.
There's no violation of any of the conditions, Your Leadership.
I appreciate your concern, but let them respond.
Your Leadership.
Next Friday, next Thursday we can.
Thursday, 8th and 9th also, my senior is out of station. Some marriage in the school.
8th and 9th is out of station.
8th and
Can be posted on 10th,
Yes,
right?
yes.
CRNP number 1918 of 26. The learned counsel for the parties are present. The counsel for the opposite party prays for short adjournment to file a counter affidavit as the matter relates to release of passport.
Temporary, Your Leadership, only for 2 weeks. That's my prayer.
And accordingly, a prayer for modification of the conditions of bail.
Bail order dated 30th of April 2026.
Bail is under consideration. Post this case on 10. The counter affidavit be filed by 8th. 10th in supplementary process. To be taken up as first case.
Your Leadership, I'm deeply obliged.
At 10:30.
Deeply obliged, Your Leadership.
Item 51, CRMP 1923 of 2026.
Yes, please.
My lord, modification outlet is my solar.
One of the bailers.
My lord,
What modification are you seeking?
my lord, one of the pillar of the my lord, Previta of the Previta is the mother, my lord. But
She
my
doesn't
lord,
have any
not a
property.
subsidiary, my lord.
Appreciate it. Heard the learned counsel appearing on behalf of the parties. The counsel for the petition, this petition has been filed for modification of bail order dated 16/6/2026, passing BA number 3472 of 26. The learned counsel submits that as per the first condition of bail, the particular of the petitioner in the bail application was to be one of the bailers. He submits that the particular was the mother of the petitioner and she has no sufficient asset so as to become a bailer. He submits that the condition be modified. The learned counsel for the state has no objection. No objection? माँ के पास नहीं है प्रॉपर्टी क्या करें after hearing the counsel for the parties and considering the reported facts and circumstances. ये बनेंगे पैरविकार to this counsel for the petitioner has submitted that the present पैरविकार in this petition is ready to become a पैरvicar. Is ready to become a bailiff. Accordingly, the order dated 16/6/26, passing bill number 3472 of 26, is hereby modified to the extent that one of the bailers would be the पैरविकार of CRFP number 1923 of 2026. Let this order be communicated to the court twice. That's all. ये तो एक hearing है दोनों. क्या है?
VA 5179 of 2026.
BA इतना नीचे क्यों लगा हुआ? ऊपर क्यों नहीं लगा?
Tied up matter है नीचे.
बाकी सारे भी तो टाइड अप मैटर ऊपर ही लगे हुए हैं. इसको मंडे पोस्ट पे
जी
पोस्ट ऑन मंडे. ये दिखाई तो सेकंड अपील का 5/2006 का. Why the name of the appellant is not appearing? Who is the counsel for the appellant? The counsel for the appellant in
My
this
lord,
case.
दूध पिया हुआ उसने.
हाँ देख.
दूध पिया हुआ उसने. क्या वो कलकनामा?
अच्छा. हमारे ब्रदर ही थे इसीलिए.
हाँ इसीलिए हम समझ गए.
तो नोटिस तो गया होगा ना.
हम भी वही समझे थे. जिसमें हम लोग का नाम था.
असाइनमेंट हो गया लेकिन अपीलेंट को नोटिस तो देना पड़ेगा. Rejection of claim for 2006.
जमता है.
That's the matter has been listed before this court as an assigned matter. The counsel for the appellant has been elevated to the bench, and therefore the name of counsel for the appellant is not appearing in the first list. Office is directed to issue notice to the appellant through the concerned police station along with a copy of this order so that he may take appropriate steps in this case. Post the space in the on 17th of July in the supplementary process.
What's it? Item number 52.
52 में क्या है?
मंडे मंडे
मंडे को रखते हैं अभी स्टेट काउंसिल में नहीं आज यू आर देयर फॉर द स्टेट
नो
मंडे
मंडे
जितना भी केसेस रहता है बेल मैटर सब चेकअप हो जाता है so you'll be there.
नहीं एक्चुअली मैं बैठा हुआ था उसके बाद फिर बोले लोग कि नहीं हो पाएगा तो मैं नीचे चला गया
इसीलिए जो लोग नहीं 4:30 बजे के बाद कोई एडवर्स ऑर्डर नहीं करते हैं नोबडी